Good evening. I'd like to welcome everybody to this public comment hearing on the EFSB 25-10 DPU 25-75 dockets. Kessel, if you could proceed with your opening remarks.
Yes, thank you. All right, good evening, everyone, and welcome to the meeting. My name is Kessel John, and I'm with ERG, a contractor supporting these meetings. Before we get started, I have some Zoom interpretation and housekeeping to go over. So this meeting is available with interpretation into Spanish, Portuguese, Haitian Creole, Mandarin Chinese, Vietnamese, and ASL or American Sign Language. In a few moments, I'm going to turn on interpretation on Zoom, and that will show up in your Zoom control panel as a globe icon. Once that pops up, you can click on it to select your desired language. English speakers should select English so they can hear any translated comments. I'm now going to turn it over to Dan to go over this in each language.
Thank you. The language announcement will now begin. To participate in English, please click interpretation icon and select English. For Portuguese, please.
Para entrar no canal em português, clique no ícone interpretação e selecione português. Obrigado.
And for Spanish, please.
Si alguien desea interpretación en español, haga clic en interpretación y seleccione Spanish.
And for Haitian Creole, please.
Pour entrer dans channel créole haïtien, cliquez sur l'icône interprétation et puis choisissez Haitian Creole. Thank you.
For Mandarin Chinese, please.
如果以中文普通话参加会议，请点击口语图标 Interpretation 并选择 Chinese。谢谢。
For Vietnamese, please.
Để vào kênh bằng tiếng Việt, hãy nhấp vào biểu tượng Interpretation và chọn Vietnamese.
Language announcement completed. Thank you.
Thank you. All right, I'm going to go ahead and turn on interpretation now. All right, everyone should have seen that pop up in their Zoom control panel. If you don't see it, please click on the More button indicated by 3 dots, and interpretation should be on the menu that pops up there. Closed caption is available for this meeting by clicking on the CC icon in your Zoom control panel. If you have audio issues during the meeting, you can call in by clicking on the arrow next to the audio icon, selecting Switch to Phone Audio, and following the instructions provided. If you have any technical difficulties during the presentation, you can message me in the chat box or email meetings@erg.com, and we'll troubleshoot the issue with you. I'd like to remind everyone who is speaking tonight to speak slowly and clearly for our Zoom interpreters. And if you're giving comments in person, please stand closely to the microphone. That's all I have for Zoom housekeeping, so now I'm going to hand it over to Donna Sharkey to get started.
Thank you, Kessel. On the record, this is a hybrid public comment hearing of the Energy Facilities Siting Board, which I will refer to as the Siting Board or EFSB, and the Department of Public Utilities, which I will refer to as the Department. Pursuant to Massachusetts General Laws, Chapter 30A, Section 2, the Siting Board opened a rulemaking in EFSB 25-10, and the Department opened a rulemaking in DPU 25-75 to implement the siting and permitting and related provisions of the 2024 Climate Act, or the Chapter 239 of the Acts of 2024. My name is Donna Sharkey. I will be conducting this hybrid public comment hearing. With me this evening are Jeremy McDermott, Chair of the DPU and an EFSB board member, Stacy Rubin, Commissioner of the Department and an EFSB board member, Andrew Green, Directing of the Siting Division, Veena Damaraja, Director of the Department's Division of Public Participation, Joan Foster Evans, General Counsel of the Siting Board, and Wayne Wong, Assistant Director of the Siting Division. representatives from the Executive Office of Energy and Environmental Affairs, the Massachusetts Office of Environmental Justice and Equity, and the Department of Energy Resources are also in attendance. This hybrid public comment hearing is being live streamed and is being recorded for the Siting Board's YouTube channel. We have a stenographer at this public comment hearing who will transcribe the official record of this hearing. If you're having any technical difficulty with Zoom, please use the chat function to contact ERG. Please pay attention to my video during the course of the public comment hearing and stop speaking if I raise my hand. I will do so if we have a technical issue or if I need to interrupt a speaker to ask them to slow down or speak up to ensure we are capturing everything correctly for the record. On September 12th, 2025, the Siting Board issued a decision opening this rulemaking. In its decision, the Siting Board proposed a number of changes to its regulation, which are published at 980 CMR. These changes included revising 2 chapters of regulations, adding 4 new chapters, and repealing 5 chapters of regulations. The Siting Board will propose a 5th new chapter of regulations shortly regarding cumulative impact analysis and site suitability. Also on September 12, 2025, the department issued an order instituting the rulemaking. In that order, the department proposed regulations to implement the Intervenor Support Grant Program. The department has proposed a new chapter, 220 CMR 34, and will propose an additional new chapter soon regarding Siting Board application fees. We will be presenting the changes to the Siting Board regulations later in the evening. In the September 12th decision and order, the Siting Board and department announced a series of hybrid public comment hearings across the Commonwealth. This is the 4th and last of those hearings. In addition, the Siting Board and department provided notice that they would accept written comment on the regulations. Final written comments are due this Friday, November 7th, 2025. Instructions on how to file comments are in the notice on the Siting Board and department's websites. After we complete these public comment hearings and review the comments, the Siting Board and the department will adopt final regulations. The 2024 Climate Act requires that we complete our rulemaking by March 1st, 2026. The regulations will apply to projects filed with the Siting Board on July 1, 2026 and afterwards. We note that the Department of Energy Resources is proposing regulations to implement the consolidated local permitting provisions of the Climate Act. In addition, the Executive Office of Energy and Environmental Affairs and the Office of Environmental Justice and Equity at EEA are issuing guidance for certain provisions of the Climate Act. I would like to introduce the Chair, Jeremy McDermott, and Commissioner Stacy Rubin from the department, who will make some opening remarks. After the opening remarks, Siting Board and department staff will make a presentation on the regulatory changes. Chair McDermott.
Hey, folks. Good evening, and thank you for coming tonight. My name is Jeremy McDermott, and I am the chair of the DPU and a member of the Siting Board. I'd like to reiterate the department's gratitude for all of you for coming tonight. And I also want to recognize the efforts of the team who has put this package together and who has been working for over a year on making siting and permitting improvements and opening the processes of both of the Siting Board and of the department to more to better to have access for more folks. The team on the siting and permitting improvements has been working daily for more than a year to get to this moment, and I'm deeply grateful to the staff for their commitment on these regulations. Tonight's hearing represents an important milestone as we gather to share an overview of the siting and permitting changes that the board proposes and to get your feedback. If we go to the next slide, I'll take a moment to explain how we got to today's milestone. Governor Moore Healy signed Executive Order 620 in September of 2023 and established the Commission on Energy Infrastructure, Siting and Permitting. This commission was tasked with reducing the permitting timelines, ensuring that communities impacted by energy infrastructure have input on the siting and permitting of such infrastructure, and ensuring that the benefits of the clean energy transition are equitable across the Commonwealth. The commission had representatives from labor, environmental justice, economic development, housing, real estate, environmental protection and land use, agriculture, local government, electric utilities, as well as the clean energy industry. That commission submitted recommendations to the governor in March of 2024, which informed the development of legislation that was ultimately enacted in November of 2024. The new law, which we've referred to as the 2024 Climate Act, or the Climate Act, reduces the time for permitting through a consolidated permit process, adds requirement for engaging with impacted communities, and should contribute to the equitable clean energy transition in the Commonwealth. We anticipate that there will be an increase in the number of clean energy projects that will seek siting board approval in the coming years. The Climate Act directs the siting board to issue consolidated permits, including state and local permits for clean energy facilities. Those facilities that are small clean energy infrastructures facilities will typically seek a consolidated local permit. Our sister agency, the Department of Energy Resources, held information sessions and a public hearing a few weeks ago to obtain input relating to the small clean energy infrastructure facilities. Again, thank you for joining us this evening, and I'm now delighted to pass the microphone to my colleague, Commissioner Stacey Rubin.
Thank you very much, Chair McDermott. Good evening, everyone. We can turn to the next slide. I'll just reiterate, I'm Stacey Rubin, and I serve as a Department of Public Utilities Commissioner, as well as a member of the Siting Board. We're thrilled to be here at the North Shore Community College here in Lynn, and thank all of you for joining us. We have offered a variety of opportunities for public comments. Tonight is a formal public comment hearing where we are recording the meeting and will produce a written transcript. Prior to tonight and the 3 other public hearings we have had, department staff, along with staff from the Executive Office of Energy and Environmental Affairs, the Office of Environmental Justice and Equity, and Department of Energy Resources held 4 stakeholder sessions last spring to talk about siting and permitting and inform the draft regulations that we are discussing tonight. Staff representatives of the agencies also met with stakeholders in smaller groups. The Siting Board met in July and September of this year in open meetings, where we also heard from members of the public. Tonight is another opportunity for you to share your ideas and give us feedback on the proposed regulations. As Presiding Officer Shargi mentioned, we will accept written comments through this Friday, November 7th. I want to note there are several different proceedings underway simultaneously. There is the Siting Board proceeding docketed as EFSB 25-10. There is a separate proceeding at the department focused on the Intervenor Grant Support Program, docketed as DPU 25-75. The department will open a new rulemaking focused on the Siting Board application fees in the coming weeks. The Siting Board will also issue its cumulative impact analysis regulations as part of the EFSB 25-10 docket. We are holding a cumulative impact analysis webinar tomorrow, November 6th at 2:00 p.m. The draft cumulative impact analysis regulations and guidance from the Office of Environmental Justice and Equity are now available on the Siting and Permitting website. We are welcoming informal comments, and we will have a formal comment period subsequently. The next steps include a siting board deliberation and vote on the final regulations for the entire package except cumulative impact analysis, and that will happen in January of 2026. This will be yet another public comment opportunity. For the regulatory packages that are open now for public comment, including the Intervenor Grant Support Program, we will promulgate final regulations before March 1st, 2026. The Siting Board aims to promulgate final cumulative impact analysis regulations in May of 2026. I'll also just note that there are currently 9 Siting Board members, which includes 6 government agency representatives and 3 public members representing environmental, energy, and labor interests. Starting in March of next year, there will be 11 Siting Board members, which includes 7 government agency representatives and 4 public members that will represent environmental justice or indigenous sovereignty, labor, municipal permitting, and municipal planning agency interests. Let's move to the next slide. We have received initial comments on the proposed regulations that were due 2 weeks ago. These comments are posted online in our respective file rooms. Thank you so much for these initial comments. Staff are reviewing and cataloging those comments received to consider further edits to the proposed regulations. We will also consider the final written comments that we receive by the end of this week. Again, as Chair McDermott noted, our team has been working daily for more than a year to get to this moment, and we've had numerous public comment opportunities that has been essential to improve our work. Our work is better with your input, so thank you so much for making time in your busy lives to be with us tonight in person and virtually. I will now turn it back to Presiding Officer Sharkey.
Thank you, Commissioner Rubin. Would staff like to begin their presentation regarding the regulatory changes?
Yes.
Mr. Green?
Thank you. So we'll get into the details now of what's happening with the revisions to the siting and permitting process that came about from the 2024 Climate Act. The slide that's up right now sort of lays out really the big picture architecture of how energy facility siting is going to transpire. There's a segmentation between large clean energy infrastructure facilities, which is the column on the left. This is the sort of segment of the electric industry that is regulated by the Energy Facility Siting Board. We have primary jurisdiction over the siting of these larger facilities that are described in the different rows of this chart. I'll just point out that these have changed with the new Climate Act. The threshold for electric generating facilities has been reduced from 100 megawatt hours down to 25 megawatt hours. And that applies both to clean energy infrastructure as well as what we call legacy generation facilities that typically burn some type of fossil fuel to generate electricity. Energy storage facilities, think of them as large utility type battery installations. This is a new facility for the Energy Facilities Siting Board to have responsibilities for siting and permitting. That threshold for the large facilities was set at 100 megawatt hours. Again, I want to distinguish the megawatt hours from megawatts. This would typically be a pretty good size facility with multiple containers of batteries, just to sort of benchmark that. And for transmission and distribution projects, which are sort of the backbone of the whole energy infrastructure system, These are pretty much the same thresholds that the siting board has had traditionally. Over 1 mile in new corridor would be a jurisdictional facility if it exceeds 69 kilovolts. Over 10 miles in an existing corridor, if it's 115 kV and above kilovolts. The other column shows the small facilities, small clean energy facilities, which are being overseen by the Department of Energy Resources, and they're developing regulations for local governments to implement the siting reform requirements of the Climate Act. As you can see, these are below the thresholds that are applicable to the siting board. Next slide, please. Sorry about that. In terms of new features that are part of this siting and permitting reform process, the big change, which the chair alluded to, is the timing issue, sort of a more expedited process where the large projects that the siting board reviews will now have to be completed within 15 months after the application is deemed to be complete. That doesn't happen necessarily right away. There may be some time to achieve the status of being a completed application. The siting board does have some responsibilities for small clean energy facilities. It's not a complete separation between the DOER program and the siting board program, but the projects that come to us that are in that small category elect to seek siting board approvals. And it could be a transmission and distribution project which chooses to come to the siting board. It could be local government deciding that it does not have the resources to review small clean energy projects, and they can transfer those cases to the siting board. That has a 12-month deadline. If we do not meet the applicable deadlines of 12 or 15 months, we being the siting board, the Climate Act actually requires that the project be deemed approved in a mechanism called constructive approval. You'll hear more about that later, but that is a new feature of siting and permitting that really guarantees that these timelines will be observed and enforced. There's also another process, again, that you'll hear more about called a de novo review, and I alluded to this just before, which is where a small project at the local level comes to the EFSB, either in a situation where some entity is challenging an approval or a denial by local government, or it may be the case where local government does not have adequate resources and elects to transfer the case to the siting board. There are many, many critical roles here in this whole process, even though authority is being somewhat centralized, you could say, within the auspices of the siting board. There's an extensive pre-filing process, which you'll hear about from our Director of Public Participation. That involves the entire community and different stakeholders. We very much need recommendations and advice from other state and local permitting agencies. And our regulations actually speak to that and have a structured process to get those recommended permit conditions. And the board will place great emphasis on making sure we understand those recommendations and using them where applicable. So those are some of the hallmarks, I think, of the new siting and permitting system that really are kind of the high level themes that you'll be seeing as we develop these regulations. Thank you.
Next slide, please. So as Commissioner Rubin stated, there's some changes to the siting board itself. Again, the siting board would be the decision-making body for applications to construct generally large energy facilities. The reason for the siting board changes is to increase the expertise and broaden the perspective of the siting board as it makes its decisions on these applications. We note that the siting board will continue to review what we call legacy facilities or non-clean facilities, in addition to the new clean energy infrastructure facilities that Director Green was speaking about. We note that there are also new considerations or a new statutory mandate for the siting board and broadens the types of things that the board must consider when it makes its decisions, including a requirement that the board consider something called the mitigation hierarchy, which is to take a look at the impacts of a project and avoid, minimize, or mitigate those project impacts. The Act formalizes a longstanding policy considerations, including labor, economic and environmental justice and equity, public health and safety. And I note the public health one in particular, as we will be getting a representative from the Department of Public Health to join the board next March. Thirdly, the Act requires consideration of recommended permit conditions by local governments and other state agencies. So while the siting board would be issuing the permits, the Act explicitly requires us to consider recommendations by other agencies during our process. The Act requires that the board consider cumulative impact analysis, which we will talk about a little bit more, and also whether or not an applicant has completed its pre-filing requirements. And we need to take into consideration climate change impacts. I'll note that the changes to our board regulations and our procedural regulations will implement these changes. Next slide, please. So this slide just lists out the regulations that the siting board and the department and DOER will be either changing or issuing as new. As stated before, the siting board is revising 2 sets of its current regulations, in part to implement the changes from the Climate Act and to update some of those regulations. For instance, explicitly allowing electronic filing as opposed to paper filing, which is what is in there right now. The siting board will issue 5 new chapters of regulations. And I will note that the 980 CMR 15, the cumulative impact analysis and site suitability, will be provided for public comment shortly. That one is not part of the package in front of you right now. We are looking to repeal actually 5 chapters of regulations. We had proposed to repeal a 6th chapter, but during the comment and stakeholder process, we found out that another agency is actually using that regulation. And so we will be keeping it, and that is at 980 CMR 9.00. And it has to do with Coastal Zone Management Organization. As stated before, we have 2 new regulations from the Department of Public Utilities and a new regulation from the Department of Energy Resources. Many of these regulations have associated guidance documents that will also be issued. Next slide, please. This rather busy slide attempts to provide a little map about how one of our proceedings would run. So there's a pre-filing portion of the proceeding before the application is filed with the siting board. That may include some work on cumulative impact analysis and or site suitability. Once the application is filed with the siting board, we go into an adjudicatory proceeding. And what that simply means is a somewhat formal proceeding, which includes notice of what's going on in the proceeding. It allows parties to participate in the proceeding, and it requires the siting board to issue decisions based on evidence presented in the proceeding. And all of it has to be in writing. During this adjudicatory process, I like to say it splits up in approximately 3 phases. The first phase on this chart is the notice and public comment hearing phase, where we determine whether or not an application is complete. We provide notice of the proceeding. We go out and hold a public comment hearing out near where a project is proposed, and issue some procedural documents at that point in time. The next phase is the evidentiary phase, where the siting board staff and parties can ask questions. We hold hearings where the parties present witnesses, and we allow briefing on the issues. And then finally is the decision phase, where staff draft a tentative decision. We present it to the board, and the board meets in an open meeting to consider the decision and vote on the decision and issue a final decision. Next slide, please.
I will be providing an overview of the pre-filing regulations. So applicants of clean energy infrastructure facilities are required to meet pre-filing consultation and engagement requirements before they file their application with the siting board. The DPU's Division of Public Participation, or DPP, will oversee pre-filing requirements and will also be available to assist applicants and stakeholders in navigating and clarifying any pre-filing requirements all through the process. The pre-filing regulations specify the nature of project information the applicants are required to share when they meet with key stakeholders, with permitting agencies, as well as the community. It covers the efforts that they need to make to consider and integrate the input that they receive from stakeholders. Pre-filing regulations as a whole will support greater transparency and make project information available to stakeholders via multiple outreach channels. Pre-filing regulations ensure that there is consistency in consultation and engagement practices across projects. The requirements expand opportunities for input by members of the community as well as key stakeholders like project abutters, residents, community groups, municipal officials, labor representatives, and federal and state acknowledged and recognized tribes. Pre-filing regulations have two distinct components to it. First, a consultation requirement that requires applicants to meet with the Massachusetts Environmental Policy Act Office and other state, local, and regional permitting agencies that are relevant to that project. At these meetings, applicants will receive feedback on compliance with regulatory requirements. They will understand if there are any studies or analysis that need to be carried out and the best practices that they need to take into account to minimize or avoid impacts. Second, the applicants are required to engage with relevant key stakeholders all through the pre-filing outreach period to inform, seek input, as well as be responsive to questions and feedback that they receive on the proposed project. Applicants are also required to conduct at least 2 public meetings to get community input, create a project webpage that includes current project information, and provide quarterly project updates via an email distribution list. The regulations establish robust pre-filing consultation and engagement requirements while also providing applicants with the flexibility, both in timing as well as the duration, to meet these requirements. To keep DPP informed of progress, applicants will be required to submit to DPP a self-attested pre-filing engagement status checklist approximately midway through their pre-filing period, and also a pre-filing engagement completion checklist at the conclusion of their outreach efforts. These checklists are accompanied by supporting documentation with specific information on agency consultation that has been carried out, as well as the community outreach efforts. The applicant can submit the project pre-filing notice no less than 45 days and no more than 90 days before filing the application with the siting board. DPP will review the information that is submitted by the applicant, as well as any comments that are received from permitting agencies. It will then incorporate that feedback into the DPP opinion that is sent to the board for consideration during the permitting process. Next slide, please.
So really the heart of the new siting and permitting process revolves around this notion of there being a, quote, standard application. That's the terminology used in the Climate Act. And that term doesn't quite fit the reality given that the siting board will have many, many different situations to address. In some cases, we will be asked to issue all state and local permits for large clean energy infrastructure facilities. In other cases, it may be a small clean energy facility, and the siting board's role may be limited to issuing state permits. And of course, there are a variety of different clean energy facilities, from energy storage to transmission to generation and so forth. So a lot of different characteristics, a lot of different permitting situations. So a standard application has to be sort of all things to all applicants, if you will. The Act specified a few different things that feed into developing a standard application, including establishing baseline environmental health and safety standards. So these are kind of the rules of the road that would be expected of any project applicant to follow the whole array of different state legal and regulatory requirements that, again, relate to environmental health and safety, and to have those spelled out in clear terms so there's no ambiguity about that. Another requirement that, again, connects to the application process is what's called common conditions. If we have a circumstance where the clock has run out, we've exhausted the 12 or 15 months that's available to the siting board to reach a decision, and the project therefore would be constructively approved, the common conditions are meant to be sort of the default conditions that would apply to ensure that there is adequate protection of public health, safety, and the environment, even in the absence of a board decision. We hope that's not the case. We're going to try very hard to avoid that and get our job done in the time that's allotted to us. But the common conditions are the fallback mechanism to make sure that, again, the public, the environment are being protected. We've issued a guidance document that covers the array of information that we feel is necessary to deal with the complexity that I just described. It's been out for review. We will be shortly issuing our document of these baseline standards, as well as the common conditions for additional review, public input, and comment. These are very important features of the program, and we do hope to learn more about the reaction and whether we've perhaps overlooked some things that are necessary or have some alterations and clarifications to do. I do want to point out, by the way, that our approach to applications is a little different than what some other states are doing. We refer to our approach as aggregation of existing applications. So there will be a set of information requirements that are unique to the siting board, things that we are very interested in and fall into our statutory review mandate. But we're also interested in using the existing vehicles of applications prepared and used by the Department of Environmental Protection, Department of Conservation and Recreation, and so forth. So our combined application or common application will be a sort of grouping of different individual permit applications that would relate to the specific permits that are being sought. Next slide, please. This is really just a sort of conceptual map that kind of covers what I was just describing. How do all these different things link together? And in the middle of it, in the sort of square box, you have the actual application. There are two flavors of the application. The larger green area is what we call the consolidated application. That's the all state and local permit variety of what we will be taking in as applications. And the smaller sort of brownish oval shape is just the limited state permits that would be called a consolidated state permit. And as mentioned before, we have the different baseline health and environmental and safety standards that are feeding into the contents of the application. We have other application forms on the right side of this diagram that we're also internalizing in our consolidated process. And we have these common conditions, again, in the event of constructive approval. The application will be visible to the public on an information filing portal. I'm sure everybody who's tuned in tonight knows about the DPU e-file room. We're hoping to add features and perhaps have a completely new portal for siting and permitting that would be jointly undertaken with the Department of Energy Resources, both for state needs as well as needs of local government. And then finally, on this diagram are the application fees. These application fees would be required of non-utility applicants, being that the utilities have an additional assessment that's in the statute to cover costs of reviewing their applications and so forth. And once fees are collected, they would go towards the administrative costs of the siting division, our staff who review these applications. A portion would be available to help with the intervener support grant program. And we are also hoping to have some funds available to provide other permitting agencies who will no longer be receiving the applications under the new system, and therefore they will not have the filing fees that go with the applications, but they still have quite a few responsibilities. So we're hoping to essentially hold them harmless and give them resources they need to do their job. Next slide.
Once an application is filed with the board, at that point, community groups and other entities can decide whether they want to more actively participate in that proceeding and intervene in that proceeding. Interveners play a formal role and have greater involvement in influencing decision-making in a proceeding. They can present evidence, cross-examine witnesses, and appeal a final decision. Intervening and participating in a proceeding is usually very expensive, and traditionally only those with financial resources and an understanding of procedural requirements have been able to promote their interest in either a DPU or an EFSB proceeding. The Intervener Support Grant Program will provide grants to community groups, smaller municipalities, and other eligible entities who are unable to participate in a DPU or EFSB proceeding due to financial hardship. It'll enable diverse voices to represent their interests and meaningfully participate. Grantees will be able to cover fees for attorneys, expert witnesses, community experts, administrative, as well as other eligible costs. To receive funding, grantees will need to comply with eligibility requirements of the program. They will also need to apply and be granted intervener status in a proceeding. The 2024 Climate Act authorizes the DPP to administer all aspects of the intervener program. The regulations cover the eligibility criteria to receive funding, the grant application process, grant amounts, eligible uses of funding, as well as the reporting requirements for grantees. A recording of the public hearing held on November 3rd focused on the Intervener Support Grant Program and is available on the department as well as EFSB YouTube channels. And the slides are also available on our website. And we appreciate the comments that we've received so far and look forward to further comments by the November 7th deadline. Next, please.
So the Act provided a mechanism to ensure that the Siting Board and the Department of Energy Resources programs run by the local governments, the issues decisions in a timely manner. And that mechanism is called a constructive approval. So what happens when an applicant does their pre-filing, files an application with the Siting Board, the application is deemed complete, the Siting Board runs its adjudicatory proceeding, we go through hearings and briefing, and it looks as if their Siting Board is not able to issue a final decision in a timely manner by the deadline. What happens is constructive approval. In other words, an application is automatically approved. So we provided some regulations to propose some regulations to say how that would happen. And how that would happen is we've set up a process where as we get toward the end of the statutory period, either the 12 months or the 15 months, the presiding officer in a proceeding would evaluate the proceeding and determine whether or not it is likely that a constructive approval may issue. And the presiding officer makes that determination and issues a draft constructive approval permit. There's a comment period. And then once the deadline hits, the constructive approval permit would issue automatically. The actual presiding officer would actually issue the piece of the document a couple of days later, but the actual approval would happen on an automatic basis. And that is how the constructive approval will work. As Director Green said, we're expecting this to happen rarely, but we did want to provide a process for how it would happen should it happen. And the time the constructive approval permit issues, it will have those common conditions attached to that permit. Next slide, please. The other element I wanted to talk about briefly is a de novo adjudication. So there's two different ways that a consolidated local permit application could get up to the siting board. Again, consolidated local permit, these are for smaller facilities. First of all, the local government may act and issue its final decision, could be an approval, could be a denial of an application. And if one of the parties below, a person who's substantially and specifically affected, does not like the decision below, they may ask for a short 6-month proceeding up at the siting board called a de novo adjudication. The second way that a local permit could get to the board is if a local government receiving an application for local permits decides that it does not have the resources to process that permit application in the required 12 months, and they can send that permit application up to the siting board for the siting board to run the procedure and issue the final decision. The decision is issued not by the full board in these instances, but the Act provides that the decision would be issued by the siting board director. So it's a more streamlined and shorter process. Next slide, please. So this map again shows how a local consolidated permit application might get to the siting board. The first path is where the local government acts and makes its decision, and there's an entity below that is unhappy with the decision and wishes for an adjudication up at the siting board. That is a 6-month proceeding. So, or secondly, we could have a situation where the local government has decided it cannot process an application, and they send the whole application up to the siting board for processing and decision. And in our regulations, that would be a 12-month proceeding that matches the 12 months that the local government would have had to look and issue the consolidated local permit in the local government. So what does the siting board look at in these instances? First, the siting board would look at consistency with the regulations that are established by the Department of Energy Resources for consolidated local government, consolidated local permit applications. And so those are under 220 CMR 29. Secondly, as an overview, the department would also make sure that the project was consistent with the siting board's statutory mandate. So those are the two things that we would look at in a de novo adjudication. Next slide, please.
So I'm going to bring up the topic of cumulative impact analysis. This is one of the new features that has been introduced broadly to siting and permitting as a result of the Climate Act. This is something that many participants in our cases have been asking for. for quite a few years, and I think the legislature heard that interest and enshrined it in the Climate Act. What is the cumulative impact? And by the way, this is a subject that we will be addressing in detail tomorrow at a webinar. So the information is out on the webinar that will begin at 2 o'clock tomorrow afternoon. So this is really just sort of a little bit of a taste of what we'll be presenting tomorrow. But cumulative impact is the combined effect of past and present industrial, commercial, private activities, municipal, government projects, and so forth, on the environment, on public health, as well as the effects on climate change. And so this is a very broad concept that really looks quite holistically at projects, not in isolation, but in the pattern of everything that's preceded it in the community that, you know, may be showing up in different sorts of health indications or environmental impacts that are seen and felt, you know, in everyday life. The Climate Act directed the Office of Environmental Justice and Equity, and our colleague, Undersecretary Maria Belen Power is here with us tonight. Thank you very much. OEJE, as the acronym goes, has been developing extensive guidance to help with the formulation of the regulations for cumulative impact analysis. That draft document is out for review, as well as a proposed draft regulation that the Siting Board staff has developed that's still at the early stage. It's not even out for official public comment yet. This is more for discussion purposes. So that's, again, the purpose of our webinar tomorrow, is to present all of the above and get some good feedback from members of the public and stakeholders as to whether we're on the right track or whether we have some refinements to consider. One critical feature of the cumulative impact system is where is the data that informs these very important questions? Again, this is another work product of the Office of Environmental Justice and Equity. They've developed a database and a mapping tool called Mass EnviroScreen that is now available for public use. It's not official yet, it's early stage beta testing, but it includes a variety of different environmental and public health and socioeconomic data in indicator form from various publicly available sources. And it maps, you know, all of the census block groups in the state, which are developed by the US Census Bureau. Those are the defined population areas that include somewhere between roughly 1,000 and 3,000 people. And the guidance that OEJE has put out has a concept called a burdened area, which identifies census block groups that tend to have higher levels of either environmental or public health difficulties. And there is a statistical measure that actually sort of aggregates data among 30 different indicators. And if that aggregation results in a census block group being at the 75th percentile of census blocks around the state, then that would be the threshold where that area is deemed to be a burdened area. Burdened areas are sort of the linchpin of the whole cumulative impact analysis. Those communities are really the focus of where we would be looking in our proceedings at what impacts projects have that may worsen environmental conditions, public health, or have socioeconomic impacts. And if there are, again, adverse impacts that are happening in those burdened areas, the project or developer would have an obligation to avoid, minimize, and mitigate those impacts in a very extensive manner. And this is on top of the fact that siting board approvals always require that same concept of avoid, minimize, and mitigate. This is an additional obligation that would be placed on the developer to address the extra impacts, if you will, in the burdened areas. So again, tune in tomorrow, 2 o'clock. We look forward to seeing as many of you as we can. Next slide, please. A related concept that sometimes gets a little hard for, I think, stakeholders and members of the public to distinguish is what's called site suitability assessments. This comes out of a guidance effort that was developed also at the Executive Office of Energy and Environmental Affairs. And it's kind of a different way of looking at the wisdom of siting clean energy facilities in particular geographic locations. I would say, one of the key differences between cumulative impacts and site suitability is really the emphasis. There's some common features of both. Both of them use the mass enviro screen, which I was just talking about, but site suitability focuses much more extensively on natural resource implications of projects in terms of potentially taking agricultural resources out of productive use. Think of prime agricultural soils and very productive farmland. It looks very deeply at the question of biodiversity and whether projects are disrupting habitat areas and potentially, having an adverse effect on the ecosystem in that regard. Another component is the carbon storage implications of projects, deforestation, soil impacts where carbon can be stored. These are concerns of the siting board. We have always been focused on these issues, but the site suitability assessment process turns that into a scored analysis with an expectation of additional mitigation, avoidance, and minimization, where the scores point to significant degrees of impact on these natural resources. There is also a social and environmental component that, again, comes out of the mass enviro screen data. And this is probably the most common element between cumulative impact analysis and site suitability, but that's probably about 20% of the overall score in the site suitability system, whereas it's really the dominant theme of cumulative impact analysis. Again, environmental impacts, public health, and so forth. So we'll be talking about this as well tomorrow. Our proposed regulation does include both cumulative impact and the application of site suitability. One very important final point to make is that it's really a one or the other type of scoring requirement on applicants. If the project is in or near, again, the so-called burdened area, a cumulative impact analysis will be required, not a site suitability assessment. If we are not seeing the project near a burdened area, then a site suitability assessment and scoring would be expected, with some exceptions. And one of the prominent exceptions in the Climate Act is for existing corridors where we already have an established public right-of-way. That is exempt from site suitability scoring. So again, some similarities, but quite a few important differences between these two scoring methods. Next slide, please.
We will now begin with the public questions and comment portion of the public comment hearing. We will now take questions from the public. The purpose of this public comment hearing is to hear comment on the proposed regulatory changes to implement the 2024 Climate Act. We ask that you focus your comments on these regulations. We will not be taking comment on particular projects, including those projects that are currently under review by the siting board or department. We will begin with federal, state, and local officials appointed as well as elected who wish to be heard. Then we will proceed with the members of the public who have signed up to speak in the order in which they have signed up. Finally, we will allow anyone who wishes to speak but did not have the chance to let us know in advance speak. If you are participating remotely and I call upon you to speak, we will move you into the Zoom panel so you can be seen and heard by the Zoom audience as well as those of us here in the auditorium. For all speakers, please give your name and address, spell your name, and speak slowly and clearly. Do we have any federal officials present or on Zoom that wish to comment? Seeing none, are any state officials present or on Zoom that wish to comment? Please raise your hand either in person here or on Zoom. Are there any local officials present or on Zoom that wish to comment? Please raise your hand either in the room or on Zoom. Seeing none, next we will take comments from members of the general public, beginning with those who have pre-registered in the order in which they registered. When called, please give your name, spell your last name, and then give your address. Kessel, do you know if we have any pre-registered speakers?
The only person who pre-registered was Carolyn Healy. I do not see Carolyn in Zoom. However, if you are here, perhaps just using a different name, please raise your hand. And if you're in person, again, please raise your hand. So Carolyn Healy. All right, somebody has raised their hand. J2412513. So if this is Carolyn Healy, I'm going to promote you now. All right, you should have gotten a little pop-up box. Yep, good.
Again, please begin with saying your name and address and spelling your name for the court reporter.
All right. Person who is J2412513, you should now be able to turn on your microphone and your camera.
Okay, can you guys hear me?
Yes, we can. Thank you.
Yes, thank you. First of all, thank you for the presentation. This is Ida Guloy, and I am the Director of Environmental Compliance.
I'm sorry. Could you just stop? Go a little more slowly and speak up a little. We'd appreciate it. It'll make it easier for the stenographer.
Okay, thank you. So this is Ida Guloy, and Ida is spelled A-I-D-A. Guloy, G-U-L-O-Y. And I am from JIRA Americas. I'm the Director of Environmental Compliance from JIRA, J-E-R-A Americas. And my question is just to clarify between the site assessment and the, what's the other one? I heard somebody, and the site assessment and then the cumulative impact analysis? My understanding is you don't have to do both. It's one or the other depending on the size of the project. Is my interpretation correct, or the one that I heard correct?
Mr. Green, could you respond to that?
Yes, if I left the impression that the difference between having to do a cumulative impact assessment versus site suitability was about the size of the project, that would not be accurate. It really has to do with, first of all, whether the project is in or near what we've called burdened areas, which again is based on a statistical measurement of environmental and health and socioeconomic data in census block groups. If a project that the siting board is reviewing is in or near a burdened area, in all likelihood, it would have to perform a cumulative impact analysis and not a site suitability assessment. That's how it breaks down. It's not necessarily a function of the size, but more the proximity to these communities that, again, are experiencing higher degrees of environmental and public health burdens.
That's very helpful. Yeah, I know that there's a difference in when those are triggered, and I must have heard it wrong. So can I ask one more question?
Please do.
Yes, so on the slide 8, with regards to the large or small CEIF, so what happens if the generation is greater than 25 megawatts and storage is greater than 100 megawatt hour, but the transmission and distribution is less than 1 mile long new corridor or less than 10-mile long existing corridor? Would that be considered large or small, or how would that be classified?
I'm assuming that in your question, you're grouping these different facilities together, let's say, as part of the same project, that maybe there's a battery that's over 100 megawatt hours or a generation facility over 25 megawatts, but the transmission line falls, below the 1 mile or 10-mile distance. Is that the question that you're asking?
Yes, that is correct. Yes.
Okay. So the sort of largest individual component of a project that might group together different types of facilities would determine whether it, achieves the level of being a large facility or whether it would be left as a small facility. So in your example, where I think you were specifying that the generation size is over 25 megawatts or the storage is over 100 megawatt hours, any transmission lines that connect those facilities to the grid at a substation, even if they're not themselves large transmission facilities, that whole project would be treated as a large clean energy facility. It would come to the board for a review of all of those related components.
Thank you. That's very helpful. That's all I have. Thank you so much.
Thank you. The next person who has their hand raised is online. Is it Shamaya Turner? I'm sorry if I'm mispronouncing your name.
Good evening. My name is Shamia Turner. I live at 10 Forest Vale Road, Hyde Park. My name is spelled SHAMAIAHTURNER. Today, I am representing the Sheet Metal Workers Union. I am a representative of that union, as well as a member of the Green Justice Coalition with Community Labor United. And my comments are speaking for the members of both those organizations. First, I want to express robust support for the importance of community benefit plans and agreements that are in the guidance. The process for meaningful participation and ensuring the benefits and burdens of the clean energy transition are shared fairly is crucial to these guidelines. Second, we are really supportive of the OEJE's inclusion of community-based organizations. EJ organizations and labor unions are listed as the key stakeholders, are also very important to this endeavor. To further ensure the involvement of labor entities, we recommend including central labor councils and building trades councils as well. And that way we can ensure that all aspects of the labor community are included in the important discussions about community and worker benefits. Some other recommendations that we have: we do strongly support the inclusion of examples that emphasize equitable pathways for local residents, women, and people of color. I believe the current guidelines, though, express these as quotas, which are not allowable under the U.S. anti-discrimination and other laws. Instead, we
I'm
recommend
sorry,
language.
could you just slow down a little bit? We're having a little trouble.
Oh, sure. Sorry. Thank you. Thank you for providing that.
Could you go, how far back? Could you go back maybe a couple seconds in your remarks?
Sure. Sorry.
Sorry.
We do strongly support the inclusion of examples that emphasize equitable pathways for local residents, women, and people of color. However, the current guidance, I believe, expresses these as quotas, which are not allowable under the US anti-discrimination and other laws. Instead, we recommend the language of goals and removal of any reference to things that are illegal. Also, we recommend that in the definition of economic development and workforce, that it be expanded to emphasize that good jobs not only provide family-sustaining wages, but also benefits and a voice on the job, such as that provided by a union. We believe that these goals are equally applicable to large and small projects as well. To quote from Governor Healy's recent executive order 641, oh, sorry, I need to back up a little bit. Okay, so that was one about expanding the definition of economic development and workforce creation. And then we do have some examples that we'd like to have included. So a commitment to project labor agreements that includes pathways for local and diverse hiring. And to quote from Governor Healy's recent executive order 641, using project labor agreements to promote successful delivery of major projects, PLAs support the creation of high quality jobs and careers with competitive and sustaining wages and benefits, and increase opportunities for access to those jobs for all. We also would like to include the example of a commitment to labor peace agreements for operations. Labor peace agreements allow for the free and fair organizing process of employees if they choose to form or join a union, ensure a smooth workplace operation after the project is constructed. Also, we recommend modifying the training related example to read, support pathways to registered apprenticeship and fund pre-apprenticeship programs with proven outcomes. And a couple of last examples of meaningful commitments to address needs fundamental to economic prosperity are to include the language of providing childcare to support local community members, provide transportation support or funding to local community members, create pathways to good jobs for formerly incarcerated and or justice-involved local community members. So that was a snippet of a written testimony that we will be submitting, myself along with other organizations, other labor unions and organizations that are part of the Green Justice Coalition. Thank you so much for allowing my comments here today.
Thank you. And we encourage you to submit the comments in writing so that we can fully capture everything that you were trying to convey in your oral comments tonight. Thank you. Next is Deirdre Buckley.
Deirdre, you should have just received a pop-up on your Zoom screen saying something along the lines of the host would like to promote you to a panelist, and you have to accept that before you are in fact promoted. I can also prompt it again. There you go. Oh, it looks like you declined to be promoted. So I'm going to try that one more time. I don't see Deirdre anymore. They might have left.
So Deirdre, if you're having problems connecting, we're going to move to someone else on the list who wishes to speak, and hope that you can attempt to reconnect after that. Next is Angela Mele.
Good evening. Can you all hear me?
We can, thank you.
Great. Good evening. My name is Angela Mile. Angela spelled Anxhela, Mile, Mile, and I'm a staff attorney at Conservation Law Foundation, located at 62 Summer Street in Boston, Massachusetts. CLF submitted written comments on October 17th on EFSB's 2510 rulemaking regarding the implementation of the 2024 Climate Act. CLF plans to submit additional comments later this week. We appreciate the opportunity to provide feedback on how the proposed regulations can be improved to comply with the statutory mandate of the 2024 Climate Act. First, regarding 980 CMR 1, the EFSB should clarify how statutory requirements will be integrated into the review and decision-making process for facilities, including all non-clean energy projects and fossil fuel infrastructure. Second, many provisions of the regulation refer to board specifications and guidance documents. And while guidance documents are useful tools, the board should not overly rely on them, since this can risk inconsistent applications by leaving crucial details undefined. Third, on 980 CMR 1303, the EFSB should define what it means by extraordinary circumstances if it will grant a waiver for lack of compliance with community engagement and pre-filing consultation. On 980 CMR 1306, EFSB should consider extending the deadline for public comment and intervention to a minimum of 30 days. And in Section 5, the regulation should require that the board issue a written response to each recommended condition and include clear reasoning for its decision-making process. While this section of the regulation imposes deadlines on applicants, there's no requirement for the board or presiding officer to explain delays on the agency's part. And this is the case for other sections in the regulation, i.e. timely rulings, so deadlines for the board should be clear and codified. On 980 CMR 1307, the regulation states that the board may develop baseline health, environmental safety, and other standards instead of the statutory required shall. This should be amended. And regarding de novo adjudications, the EFSB should consider adopting a more permissive standard for intervention and allow documentation and evidence related to cumulative impacts or site suitability, as these are crucial considerations in citing decisions. On community engagement, CLF commends EFSB for its efforts to ensure that applicants are required to engage meaningfully with community members. To strengthen this component, EFSB should clarify what constitutes as good faith effort, prioritize engagement before site selections, strengthen notice requirements, and require tailored outreach. Regarding constructive approval, the board should consider instituting earlier procedural stops, such as a status check at 6 months, to ensure progress and reliance on constructive approvals is not too much. Finally, the board should consider an amendment in the regulation to allow for review in the next 2 years and provide an opportunity for public comment to determine whether any components should be amended. Thank you for considering these comments and working to implement the 2024 Climate Act in a way that will ensure a cleaner energy future while accounting for impacts on environmental justice communities and the need for meaningful community engagement. These comments are all expanded upon in our written comments as well. Thank you.
We would ask that in your written comments, if you have recommended language to include in the draft regulations, that would be very valuable to us as part of your comments.
Great. We will work on that for this Friday.
Thank you.
Thanks.
Is there anyone else who would like to speak tonight?
Good evening. Does this work? Okay. Deidre Matthews, Matthews, I'm here on behalf of National Grid, 40 Data Drive, Waltham, Massachusetts. And I'm here to start to thank the staff at the siting board, at the department, at DOER, all you commissioners, and having trouble with this, and everybody else who has contributed to designing the regulations for Siting Board 2.0. It's been quite a journey. To get to this point, we are really deeply appreciative for all the work that's been undertaken over the last year. We know how hard it is, and we thank you. We do have a couple of last thoughts as you move towards finalizing these rules. And I think that Deidre Buckley has a few more points if we can get her back. Big picture, one of the primary objectives of the 2024 Climate Act was to streamline the permitting of new clean energy infrastructure to make it more affordable, efficient, transparent, and equitable. The legislature chose to do this in part by creating a consolidated state and local permitting process and centering it within the siting board. In doing so, it expressed confidence that state and local agencies working together could permit and license these facilities in 12 to 15 months. We completely agree, based both on our deep respect for these agencies and for our experience with similar processes in other states. A practical, functional siting and permitting process for clean energy is a realistic goal. It's not a pie in the sky dream, and the draft regulations are an enormous step towards that goal. So again, thank you. And don't be afraid. Second, the process is going to require a certain level of certainty to work as intended. And that includes certainty about what constitutes a complete application. Perhaps also certainty about what constitutes an appropriate level of pre-filing engagement. We would therefore ask the final rule be clear that the completeness review is administrative, and that it's not a first cut at the substantive review of the project. We are fairly sure that's exactly what you intend, but we do intend to provide you with language in our written comments to make that even clearer. Third, most recent draft of this rule added some new language requiring applicants to file an application for a consolidated local permit as defined by DOER as part of their application for a consolidated state and local permit as defined by the siting board. Now, we understand the desire to create consistency between agencies when possible, but this proposal overlooks the key differences between the siting board's adjudicatory review process of every permit required for a project and the municipal agency's focus on local issues. It also, quite frankly, buries what probably is a single CONCOM application in the middle of a bunch of extraneous material and is going to make it harder for staff to find the CONCOM application and honestly for the CONCOM to find the CONCOM application. We therefore suggest reverting to the original language when you issue the final rule. Finally, we know that a lot of the substance of this process is still to be developed as part of the guidance documents that are coming to us, and honestly, as part of the process of going through the first 2, 3, 4, 5, 6 applications. We look forward to working with you folks, not just now, but over the next 6 months, a year, 2 years, to come up with a solid, simple, straightforward, competent review process for both our large clean energy facilities and our small clean energy facilities. So thank you. It's been a great ride. It'll continue to be a great ride.
Thank you. Has Deirdre Buckley been able to rejoin the public comment hearing remotely?
I do not see them, no.
In that case, I believe I see some of her counsel online. Perhaps they could encourage her to submit what comments she would have made tonight in writing by Friday. Is there anyone else online who would like to offer comments? Is there anyone else in person who would like to offer any comments? At this point, we are going to take a 15-minute break and come back and see if we have any additional commenters who may be able to join us remotely or in person. So let's go off the record and come back at 7:45. Thank you.
Maybe give this piece of her mind.
There's a wait.
So we're going to resume with comments. I believe Deirdre Buckley has been able to join us remotely. Ms. Buckley, would you like to make your comment?
Yes, I just did let me try just allow to talk. All right, Deirdre, you should be able to turn on your microphone.
Okay, can you hear me?
Yes.
Thank you for your patience and sorry to keep everyone waiting, but I did want to be at this meeting. So my name is Deirdre Buckley, and I'm the Director of Transmission Siting at Eversource Energy. First, I want to thank you for the opportunity to participate in this process and to provide input on regulations and guidance documents throughout the process. We really appreciate the significant commitment and the thought invested in developing proposals, regulations, and organizing informational sessions. It is very clear that the Siting Board has closely considered stakeholder input and incorporated many refinements and improvements into these regulations. The Siting Board and staff have made tremendous efforts to keep these regulations on track and made significant progress towards ensuring that the rules reflect the goals and mandates of the 2024 Climate Act, to expedite the permitting of clean energy infrastructure, and to provide flexibility to applicants by providing a number of permitting pathways that include filing for individual permits at the local level, filing for a consolidated local permit, or a consolidated permit from EFSB that includes all state and local permits and approvals. Our written comments will focus on several issues that we have highlighted before and that we think warrant further consideration, and these include zoning exemptions. As drafted, the regulations require that both an application for consolidated permit and a separate zoning petition be filed, which may complicate rather than simplify the permitting process, and we believe is inconsistent with the Climate Act that indicates a consolidated permit should be in the form of a composite of all individual permits, approvals, or authorizations that would otherwise be necessary for the construction and operation of the clean energy facility. We've highlighted this in our prior comments and really appreciate having had the opportunity to discuss this at public meetings. And we understand that you are considering this and appreciate your attention to this issue. We look forward to continuing to participate with all stakeholders in this process and finalizing rules that are built on efficiency, equity, and affordability. Thank you.
Thank you. Is there anyone else online who would like to offer a comment at this time? Seeing none, I'd like to read into the record a comment that was put into the chat function by the woman who is a representative of JERA. Her comment was on the comment regarding a minimum of 30 days for public comment. 30 days is sufficient, given that public engagement started during the pre-filing process. If there are no other comments at this time, I'd like to thank everyone for your comments and participation tonight. We welcome written comments so that we may consider your comments fully. Those comments are due to us by Friday, November 7th, 2025. We will be posting a video of this public comment hearing online on the EFSB YouTube channel. You may also find the slide presentation on the Siting Board and department web pages in the notice and at the welcome desk. Thank you for your help tonight. Off the record. Oh, thanks.
Yeah, EFSB.